The assault on international justice is no longer hidden behind diplomatic posturing. Under Donald Trump, the US State Department has explicitly stated its goal to dismantle the threat posed by the International Criminal Court and disable its ability to operate. Secretary of State Marco Rubio publicly framed the Hague-based tribunal as a corrupt and fatally politicized supranational court, calling on all 125 member nations to withdraw their support and abandon the Rome Statute. The Rome Statute is the international treaty that established the International Criminal Court, adopted in 1998 and effective on July 1, 2002. It defines the court's jurisdiction, structure, and operating rules, targeting individuals responsible for the world's gravest atrocities.
As we speak, the ICC and its friends are waging a war against our country, not with bullets or missiles, but with statutes and compacts and the force of so-called international law.
Through executive orders signed by Trump, the US government has deployed punitive sanctions against key court personnel. The Trump regime targeted top officials, including ICC President Tomoko Akane of Japan and senior trial lawyer Abdoulaye Seye of Senegal, blocking their assets and cutting them off from global financial infrastructure. These actions follow previous sanctions against former chief prosecutor Karim Khan after he sought arrest warrants for Israeli Prime Minister Benjamin Netanyahu and former Defense Minister Yoav Gallant over alleged war crimes in Gaza. The sanctions impose what human rights groups describe as a financial death penalty. High-ranking judges, prosecutors, and international lawyers find their personal bank accounts frozen, digital software blocked, and travel restricted. Why go to such extreme lengths to cripple an international judicial body? Because the tribunal's mandate threatens the doctrine of absolute impunity. The administration is attempting to shut down and dismantle the ICC for one underlying reason. It knows that its own policies, along with those of its closest allies, cross the line into war crimes.
The danger of this global court has only continued to grow. Today, it threatens every aspect of our political and legal system. Border Patrol agents removing violent criminals from our country. American Marines risking their lives to defend our homeland. Prosecutors working to dismantle terrorist plots to attack and kill Americans. If we stand idle, all of them would be at the mercy of foreign judges thousands of miles away, facing the constant risk of prosecution and even imprisonment for the so-called crime of defending their own country.
To understand the hostility toward the court, one must look at where international investigations lead. Independent investigators have long scrutinized military incursions and unilateral operations involving US forces and their strategic partners around the globe. The issuance of the ICC arrest warrants for Benjamin Netanyahu marked an historic moment in international law. Under definitions recognized by the UN and other international bodies, the catastrophic destruction, forced displacement, and deliberate blockade of essential human supplies in Gaza constitute severe breaches of international humanitarian law. By sanctioning the prosecutors and the judges investigating these actions, the administration acts as a shield for Netanyahu, ensuring that state-sanctioned violence remains unpunished. The shadow of legal liability extends far beyond the Middle East. Consider the Trump regime's escalating military actions in the Caribbean Sea, where the US Navy has executed lethal strikes on small vessels and fishing boats. Operating under the guise of counter-narcotics operations, the White House has repeatedly claimed, without evidence, that these boats are crewed by designated narco-traffickers and foreign terrorists, blowing small craft out of the water in international waters, killing dozens of civilians and fishermen without due process or verified combatant status, represents a blatant disregard for maritime law and basic humanitarian norms. The reach of aggressive unilateral force has also expanded into the African continent. Under the justification of targeting extremist groups like ISIS, the Trump regime launched unilateral missile strikes in northern Nigeria. These bomb strikes, executed with minimal transparency and driven by sweeping political claims, risked civilian casualties and violated international conventions governing sovereign force, from air raids in Nigeria to drone strikes in Yemen and targeted attacks near Iran. These unchecked operations consistently cross the boundary into illegal acts of war. The fear of accountability is not limited to foreign battlefields. Domestically, the aggressive deployment of federal immigration enforcement, characterized by militarized tactics, systemic detention, family separations, and severe civil rights abuses by ICE agents, represents a civil and human rights crisis. When state institutions operate with complete disregard for human dignity, the prospect of international oversight becomes a direct threat to those issuing the commands. By declaring that the US and its allies are immune from the ICC's jurisdiction, the administration sends a clear message that rules exist only for adversaries, and Donald Trump will decide who are the terrorists. The consequences of this crusade extend far beyond The Hague. The sanctions regime creates a pervasive climate of fear, criminalizing human rights defense work. Prominent advocacy organizations, including Human Rights Watch, the Center for Constitutional Rights, the American Friends Service Committee, and the Open Society Foundations, have filed federal lawsuits challenging the executive orders, arguing they unconstitutionally penalize legal advocates and civil society groups. Under the current regime, American lawyers representing victims of torture or war crimes before the ICC face astronomical fines and up to 20 years in prison simply for submitting legal briefs. Key Palestinian human rights groups such as Al-Haq have had their operations crippled, leaving field researchers unable to access bank accounts. When investigators are silenced, the ultimate victims are the survivors of atrocities from Palestine and Afghanistan to Sudan and Ukraine, who are stripped of their only remaining forum for justice. An innocent entity does not fear an independent court. A government committed to the rule of law does not threaten judges, freeze assets, or pressure allies to abandon international treaties. The crusades to dismantle the ICC brick by brick is not an act of strength. It is a desperate attempt to erase accountability. If the international community allows the ICC to be dismantled by the United States, it destroys the foundational post-World War II principle that no individual, no matter how powerful, is above the law. Protecting the court's independence is about defending human rights and ensuring power never fully replaces justice. I'm Anthony Davis. You can find me on the 5 Minute News YouTube channel and podcast, on Wednesdays co-hosting Uncovered, on Global AF, on Legal AF, and on Sundays on The Weekend Show with MeidasTouch.
Want to stay plugged in? Become a subscriber to our Substack at MeidasPlus.com. You'll get daily recaps from Ron Filipkowski, ad-free episodes of our podcast, and more exclusive content only available at MeidasPlus.com.